how to protect survivors of harassment in the workplace. This legislation required all employers, regardless of size, to establish a prevention policy on sexual harassment. It mandated that every employee receive notice of this policy and also required employers and employees to participate in annual training on sexual harassment policy and prevention. The New York State Department of Labor, in consultation with the Division of Human Rights, developed a sexual harassment prevention model policy and training for employers. It was designed to ensure that every employer and employee has access to a policy and training that meets the standards set by the legislation. Every 4 years, the department is required to review the policy and is given the option to revise it. It's a good thing that this mechanism was built into the legislation because our state, nation, and indeed the world has dramatically changed over the last 4 years. Remote work became a necessity during the pandemic, and it is here to stay. And many employers are also utilizing a hybrid model, some days working from home, some days in the office. These new work models also brought new issues. Sexual harassment did not go away when workers stopped coming into the office. It just moved to Zoom. Public-facing employees in the service sector also faced challenges. Many of these workers were at work in person every day throughout the pandemic. The line between hospitality and harassment blurred, and it was worsened by the need to keep customers happy during a time of rolling shutdowns. These are just a few examples of why we must revisit the model policy and training. No employee should have to face sexual harassment regardless of where they work. The Department of Labor and the Division of Human Rights have spent this summer meeting with stakeholders and reviewing comments submitted online by New Yorkers. We've already received input from experts from across the spectrum, including in human resources, gender discrimination, employee rights, and small business protection, as well as individuals who have experienced sexual harassment firsthand. They all provided invaluable feedback on what the current model policy is doing right and how it could be improved. Our state has evolved, and we must continue to do so to keep up with the times, but we must do so while continuing to safeguard the rights of all New Yorkers. We now have a heightened awareness of how gender, race, immigration status, and ability can interconnect to create instances of harassment and discrimination. We remain committed to creating an inclusive policy that acknowledges how different identities can impact how an employee experiences the workplace. I am so grateful to count you among our allies in this endeavor. Thank you for choosing to be an agent of positive change to continue to make New York State the greatest place to live, work, and play. After remarks from my colleagues, we will have presentations from groups representing different perspectives on sexual harassment in the workplace, including workers, employers, and legal stakeholders, all of whom are impacted by this model policy. We will hear their experience over the last 4 years and what guidance they have. Following these presentations, the hearing will open up for public testimony. The public are asked to keep their testimony to no more than 3 minutes. The public will be called to testify based on the order in which they registered online. Those wishing to speak who did not register in advance may register at the check-in table in the lobby and will be added to the list of speakers. Everyone who wishes to will have the chance to testify. And now, please join me in welcoming my colleague, New York State Division of Human Rights Commissioner, Maria Imperial.
Thank you so much, Commissioner Reardon. Good morning, everyone. Buenos dias, bienvenidos. Happy first day of Hispanic Heritage Month as well. As Commissioner Reardon said, I'm Maria Imperial, and I have the honor of serving as the Commissioner of the State Division of Human Rights, and I was appointed by Governor Kathy Hochul last year. Our mission at the division is to eliminate discrimination, remedy injustice, and promote equal opportunity, access, and dignity for all New Yorkers through the enforcement of the human rights law. We can be proud that as a state, we were the first state in the country in 1945 to pass a human rights law and to create a division charged with its enforcement. New York State's human rights law was passed to ensure that every individual has had equal opportunity to participate fully in the life of the state. Sexual harassment prevents people from participating fully in the life of the state and from reaching their full potential. It's vital that we use every tool available at our disposal to eliminate sexual harassment and support survivors. I'm proud to be part of Governor Hochul's administration, which has made this a priority. The Division of Human Rights worked very closely with the Department of Labor in the development of New York Sexual Harassment's model policy issued in 2018. We are delighted to be collaborating with the department again in this crucial process. Your feedback will help us understand how the model policy can best be updated to build more equitable and inclusive workplaces free from sexual harassment. Of course, the 2018 model policy has been updated since it was issued, as it had to be to reflect several bold new amendments to the human rights law. As Commissioner of Human Rights, it's my privilege to oversee the enforcement of a law that is now among the most protective and far-reaching in the nation. Among the most important changes was that for the first time, the human rights law contains explicit statutory protections from harassment in employment. These protections apply to all forms of harassment on any basis under the human rights law, not sexual harassment alone. These provisions apply to all employers, licensing agencies, employment agencies, and labor organizations, and set new legal standards for harassment. Under these standards, harassment is unlawful when it causes a person to be subjected to inferior terms, conditions, or privileges of employment. No longer must the harassment be shown to be severe or pervasive. That previous standard, which was applied by some courts, allowed conduct in workplaces that no one should have to endure. Instead, the employer now is limited to an affirmative defense that the conduct was more than a petty slight or trivial inconvenience. The statute further provides, and I think this is extremely important, that the standard to be considered from the point of view of a reasonable victim of discrimination with the same protected characteristics. I remember when I was in law school learning criminal law, where the standard was the reasonable man, and that was usually the problem. Another important change to the human rights law was statutory protection for non-employees in the workplace. Anyone working in an employer's workplace, even if they are not a direct employee, is protected from harassment and discrimination. What constitutes an employer has also been changed. Smaller employers with fewer than 4 employees were previously exempt from the human rights law. With the new amendments, an employer with even 1 employee is covered by the human rights law. We had previously seen cases of harassment in, for example, a very small doctor's office or a real estate office where the requirement of 4 or more employees prevented the division from investigating and adjudicating serious allegations of sexual harassment. I am very glad that this is no longer the case. There have been other changes to the law that I won't discuss here in detail, except to note that among the most important is the extension of the statute of limitations to 3 years for individuals who have experienced sexual harassment to bring a complaint to the Division of Human Rights. Further crucial changes include provisions for the award of punitive damages and attorney's fees, as well as protections for people who experience harassment and discrimination with respect to non-disclosure agreements. Information about all these amendments is available on the division's website. These changes to the law are having a real and important impact. Because of the elimination of the severe or pervasive standard and other positive amendments, we at the Division of Human Rights have seen a significant rise in findings of probable cause in harassment cases. Indeed, the percentage of sexual harassment cases with a probable cause determination following investigation has risen to 50% today from 25% in 2018. Thus, we've had more sexual harassment cases going to a public hearing before an administrative law judge, where a full record is made, testimony is taken under oath, and the parties are subject to cross-examination. We urge people who have experienced sexual harassment and other forms of discrimination to make use of the services provided by the Division of Human Rights, which are available free of charge. We have also recently made it simpler to file a complaint by introducing a new online complaint form, and a recent amendment to the law means that complaints no longer need to be notarized before being filed. These changes make the complaint process easier and more accessible to all New Yorkers. We will continue our outreach to let New Yorkers know what their rights are and that we are here to help. Earlier this year, we collaborated with the U.S. Equal Opportunity Commission on public service announcements that focused on your rights at the workplace, including a PSA on sexual harassment. We are also hosting events over the next several months with the EOC and other partners to engage professionals and legal practitioners with a focus on sexual harassment protections and the human rights law. Finally, I want to highlight our sexual harassment hotline and our new pro bono legal referral service. Earlier this year, Governor Hochul signed legislation directing the division to set up a hotline to a pro bono legal referral service so that workers who experience sexual harassment can have a free consultation with an experienced volunteer lawyer. That hotline, 1-800-427-2773, or to make it easy, 1-800-HARASS-3, is housed in our specialized Office of Sexual Harassment Issues. Thanks to the efforts of many of the people here with us today, we are able to recruit volunteer attorneys and launch this program this summer, and look forward to continuing to provide the service to New Yorkers. Thank you, and I look forward to hearing your testimony today. I now would like to turn it over to our great counsel, Elizabeth Liz Fine. Thank you.
Thank you. Good morning, everyone. I'm so happy to be here. On behalf of Governor Hochul, I really would like to thank Commissioner Imperial and Commissioner Reardon for holding these hearings. They are so important. It's not lost on me, the irony of, Governor Hochul and the issue of sexual harassment and how she took office. She became governor a little over a year ago, and I probably aged about 10 years. In the midst of what was a real crisis for the government and the executive chamber because of this very issue. And as she took the reins of government and she needed to run the entire state, the first thing she had to do was right the ship in the executive chamber and in state government and create an environment that was clearly one where people knew they could come to work and be free of any sexual harassment. And, it's one thing to talk about it, but it's another thing to really create that environment in your workplace. And there was a lot of distrust when she came into office. And one of the very first things she did as governor was to try to restore that trust for people. And she required everybody in the executive chamber to have live training, not all in person. I think there was a few over Zoom just because of logistics. So I can't say in person, but live training on the state's harassment and discrimination policy. We put posters up everywhere. And because of the concern about even reporting sexual harassment, we hired an outside firm so that people would be able to file reports of harassment or discrimination without fear of any kind of retaliation, even though they should not have to have that fear with a internal reporting system, but we needed to really set the right tone. And so we hired an outside firm to take all complaints. And she also reorganized the Office of Employment Relations. And it used to be called the Governor's Office of Employment Relations. That sends a message that the governor is, watching whoever is filing a complaint of discrimination. That had to end, and now it's the Office of Employment Relations. It may be symbolic, but I hope it has a lot of value. And the other thing she did is require that every state employee have in-person training on live training on harassment and discrimination. So there's no clicking through a little online program. So I think it's very important, as we all know, to put your money where your mouth is, and to also, if you're going to be talking about sexual harassment in the workplace, you have to start at home, and you have to show that you care about it for your own employees. And you have to do that to attract good people to work in your office. It's really completely unacceptable to go to work and have to worry about being harassed. And I am so interested in what all of you have to say. I'm looking forward to hearing the testimony today, and I hope I'll learn from it and have some lessons that we can, not just in the policy, but that we can implement ourselves in the workplace. So thank you so much for your participation, whether you're listening or testifying. We really appreciate it. And I will turn it back to Commissioner Reardon.
Thank you. Thank you both. Excellent. So our first presentation today is Da-Hae Kim. She is the State Policy Senior Counsel, Education and Workplace Justice, National Women's Law Center. It's a long title.
It is a long name. Good morning, everyone, and thank you for the opportunity to submit this testimony on behalf of the National Women's Law Center. My name is Da-Hae Kim, and I am the State Policy Senior Counsel at the National Women's Law Center. The Law Center has been working since 1972 to remove barriers to equal treatment of women in the workplace, including workplace discrimination and harassment. The Law Center also houses and administers the Times Up Legal Defense Fund, which, since it was launched in 2018, has responded to nearly 6,000 requests related to workplace sexual harassment and related retaliation, connecting individuals with attorneys and providing funding for litigation in select cases. We would like to thank the state of New York for its continued efforts to end workplace harassment. Since Me Too went viral in 2017, 22 states and the District of Columbia have passed a total of more than 50 workplace anti-harassment bills, and the momentum continues with 10 states and the District of Columbia passing meaningful workplace anti-harassment bills in 2022 alone. After laws limiting the abusive use of non-disclosure agreements, the second largest area of reform we have seen since Me Too went viral is legislation mandating that employers have anti-harassment policies and trainings. Of these states, 11 have passed bills that require public and/or private employers to conduct anti-harassment trainings, and 8 states have passed bills requiring employers to have an anti-harassment policy, including Washington, Oregon, Illinois, and localities like Chicago that, like New York, require their agencies to formulate model policies. Workplace anti-harassment policies and trainings are a baseline protection that can help reduce harassment and retaliation if they are clear about how to report harassment with multiple avenues to report it, discuss how harassment complaints will be promptly and thoroughly investigated and addressed, lay out how harassment perpetrators will be held accountable, and are tailored to their workplace. Based on concerns we have heard from advocates and lawyers from around the country that the creation of a model policy or a training can disincentivize an employer from creating a more robust and workplace-specific policy and training, we encourage the DOL to make clear on the website and elsewhere that the model policy and training are templates, a guide, and a starting point. For example, Chicago's model policy contains a disclaimer that encourages employers to build on the model to fit the needs of their specific workplace. Another principle guiding our work is that to be effective for those most impacted by harassment, like women of color, people with disabilities, and LGBTQI+ people, any sexual harassment policy must address the intersecting forms of workplace harassment. The requests for assistance that we have received through the Time's Up Legal Defense Fund have confirmed that sexual harassment often occurs at the intersections of identities, with many women experiencing harassment based on their disability and sex, for example. To this end, the model policy and training should include examples of intersectional harassment, like racialized sexual comments. We also encourage the DOL to include examples that get more directly at the types of harassment that an LGBTQI+ worker might experience, like intentional misgendering. And the policy should be clear that the examples of harassment provided are not exhaustive. While we understand the DOL was Statutorily tasked with creating a model sexual harassment policy, such a policy should, at the very least, also name the employer's commitment to a workplace free from other forms of unlawful discrimination and harassment, like race, disability, or national origin, similar to the approach Washington State took in their model policy. From our intakes, we know that a lot of employees do not feel comfortable reporting internally as they fear retaliation. The model policy should include the state's confidential hotline and anonymous reporting mechanisms, or a third party to which employees may be able to report. The model should also be clear throughout that the employee can file a verbal and a written complaint. And it should also include examples of retaliation and leave space for the employer to include industry-specific examples. Fourth, the model policy and training should include a list of community resources and supports available to employees to assist them with their experiences, or a place in the policy to name the employee who can provide such resources, like Chicago's model policy. And to ensure that more people can access and understand the model policy and make complaints, we asked the DOL to encourage employers to make sure their model policy is accessible in a way that people with disabilities or limited English proficiency are able to access and use them, by starting with making sure all the translated policy and complaint forms are easily accessible from the homepage, and by shifting the policy language away from a more compliance and legal tone to a more plain language that we have noticed in other model policies. Six, we encourage the DOL to clarify in the model policy that a confidential investigation does not mean an employee is subject to an NDA during an investigation or will be kept away from speaking and seeking further assistance. Survivors should have the power to decide whether they would like to share their story, and employers should not use a cover of a confidential investigation to keep them from taking control of their experiences. Seventh, the model policy states that an investigation will ensure, quote unquote, due process for all parties. The use of the term due process here suggests that the policy incorporates elements of constitutional law with unclear applications as to what due process looks like here. We recommend instead a term like fair process, which does not have constitutional ramifications. Finally, we encourage the DOL to directly seek feedback from survivors and employees, especially from those working in low-paid jobs and male-dominated workplaces, which experience particularly high levels of harassment. This is important as they can best share what it would be like to navigate reporting harassment and might lead to, for example, the inclusion of language as in Chicago's model policy around how employees can make leave and reasonable safety modifications requests related to sexual harassment. We appreciate your efforts and to address workplace harassment, and we thank you for your consideration of our recommendations. And we are here and happy to serve as a resource as you continue to evaluate this policy. Thank you.
Thank you. Do either of you have any questions for her?
No, this is some very good ideas here. Thank you.
Thank you.
Yes, thank you so much. Very well ordered. Thank you very much. Our next presenter is Melissa Fleischett. She is the president and CEO of the New York State Restaurant Association.
Good morning, Commissioner Reardon, Commissioner Imperial, and Ms. Fine. Thank you for holding this important hearing on the state's sexual harassment prevention model policy. When the state first launched the training in 2018, the New York State Restaurant Association, our members, and numerous stakeholders worked with the state to provide valuable feedback. This led to much appreciated flexibility and implementation for both employees and employers. There are many things the initial policy got right. We believe that allowing for various training formats, digital, in-person, group, and individual, all provide the employees and employers with options to best suit their needs. By not mandating a specific training period by which to train new employees, the state also gave great flexibility to the employees and employers while emphasizing that training should take place as soon as possible. We thank you for recognizing the importance of flexibility, as the hospitality industry has different days and hours than the typical office space. We also believe that training all employees in the state better educates all New Yorkers on how to conduct themselves appropriately, whether it be in a traditional office, a retail establishment, a restaurant, or a bar. To meet the unique needs of the hospitality industry and offer compelling industry-specific training, the New York State Restaurant Association turned to our national partners at the National Restaurant Association and began offering sexual harassment prevention for the restaurant industry under their Servsafe workplace suite of products. This interactive training program addresses and aims to help prevent sexual harassment and its harmful impact on individuals and businesses. Developed specifically for the restaurant industry, this modern, engaging course is a direct response to the changing conversation around sexual harassment. Scenario-based learning focuses on the impact on individuals and emphasizes the responsibility each employee has for maintaining a respectful and inclusive workplace. The Servsafe Sexual Harassment Prevention in the Restaurant Industry program is like no other. It was developed specifically for the restaurant industry, featuring scenarios and context that will be both familiar and relevant to food service employees. It was designed to make a positive impact on culture and go further, helping to prevent harassment from ever occurring. It is aligned with EEOC guidelines and standards and was created by industry experts familiar with the elevated risk factors associated with the unique environment of a restaurant or a hotel. While I truly believe that this training is the best option for the hospitality industry, what we quickly learned was that it was very difficult to compete against training that was offered for free. The Servsafe Sexual Harassment Prevention Program is $30 and is intended to be used by individuals. Each employee gets a video link and a key code to watch the interactive video at their own pace and respond to questions. Members of our association get a discount on the training, bringing it down to $25.50 per employee, but we struggle to compete with the free non-industry specific training from the state and the city. We knew this was happening prior to the pandemic and believe it will likely be worse now given the economic conditions of our industry. So what has changed since March of 2022? While many employees have embraced telecommuting from the early stages of the pandemic to today, hospitality remains an industry where workers need to show up in person on site to do their jobs. There is simply no other way. Throughout the past 30 months, the association has held weekly Zoom calls with operators in different areas of the state and different segments of our industry. During those calls, we have talked numerous times about the importance of staff and the responsibility our operators feel towards the individuals that work for them. Many view their staff like family. To help their employees during the shutdown, we saw employers implement feeding programs. Operators tried shared work programs for the first time, and many owners paid employees with payroll protection program funds, even when there was no work to give them. We continually hear about the importance of the team and the staff retention. Since reopening, we have seen that many employees have chosen not to return to work in our industry, which makes staff recruitment and retention more important than ever. To attract and retain staff, the hospitality industry has increased wages, provided mental and physical health resources like never before, and in a few weeks, our association will be launching a 401k program for our members and their employees. Because they understand the importance of not overworking staff that they still have, our operators have cut hours and days of the week to better manage their businesses. While many told us of difficult customers who have vehemently opposed the various restrictions we have been having to implement, we never heard that there were increased sexual harassment complaints during this time from our operators. However, we did hear a lot about very mean customers and how they became difficult to enforce various restrictions, and that put many of our employees in direct conflict with the customers. In fact, our survey from October 2021 found that 59.2% of those who responded had customers who were hostile towards or yelled and screamed at the hosts. To address this problem that was seen nationwide, not just in New York, the National Restaurant Association developed a free conflict de-escalation training that we shared with both our members and non-members for free. Our most recent survey data in August 2022, conducted in partnership with the National Restaurant Association, found these results. 91% of restaurants are less profitable now than they were before the pandemic. 41% of New York operators said business conditions for the restaurant had actually gotten worse in the last 3 months. 39% feel that business conditions will never return to normal, while 42% of operators believe it'll be more than a year before business conditions return to normal. New York restaurants have taken many actions in recent months as a result of higher costs. 86% have increased menu prices. 73% changed the food and beverage items they offered on the menu. 77% reduced their hours of operation. 47% closed on days that they would normally be open. 35% have postponed expansion. 49% have stopped operating at their full capacity. 53% have cut staffing, and 32 have postponed plans for new hires. All of them have seen costs increase across the board, like so many New Yorkers. 85% have higher food and beverage costs, 86% have higher labor costs, 70% have higher occupancy costs, and 86% have higher utility costs. So given the economic climate, we believe that the hospitality industry will continue to look to comply with the sexual harassment prevention training and policy in the simplest and least expensive way, meaning free training and sample policies that don't embrace or acknowledge the uniqueness of our industry. While the sample policy is a good start, there is more we could do to provide restaurants and bars with the information they need to deal with the situation in real time. The fact that hospitality employees interact with the public and not just coworkers complicates this issue for our industry. Not only can they be sexually harassed by a coworker or a manager, but they also must deal with a customer who, in this case, could be causing the harassment and has likely been consuming alcohol. While a standard sexual harassment prevention policy typically discusses important steps like investigations and documenting incidents, reporting the problem, and talking to those involved, a customer harassing an employee requires a real-time reaction. These scenarios are not currently addressed by standard policies, but should be. We would welcome the opportunity to work with the departments to provide our New York restaurants with a model policy for customer-employee harassment situations. When preparing for my testimony today, I recalled an article and went and researched it that was put in place by a San Francisco restaurant called Homeroom. The restaurant is run by a former attorney, Erin Wade, who worked with her team to create a system she called Management Alert Color System. It allows employees to categorize a table or situation with a specific color to explain their comfort level. According to the Grub Street article from 2018, an incident is yellow if a customer has a creepy vibe or gives an unsavory look. If a guest verbally comments on the server's appearance or says anything with sexual undertones, the situation escalates to orange. And finally, it becomes red if there's an overtly sexual act. When category yellow occurs, the server can ask the manager to take over the table or to just monitor it. Orange requires the manager to take the table automatically, and red means that the customer has to leave the facility. Mm-hmm. The article goes on to explain the benefits of the system as being twofold. It doesn't require the employee to relive the event in order to relay the information to their manager, and it takes the judgment call out of the hands of the manager. Now, we certainly don't have to adopt this exactly, but given that the industry needs a policy that addresses customer harassment and provides solutions to deal with it in the moment, this could make a big difference for our industry. We'd also appreciate it if there was any way the state could think of to help us better promote our industry-specific training and help us spread the word that it is available. Thank you for allowing me to speak on this important issue today that impacts all restaurants, but it's just as critical that we provide industry-specific solutions and future tools that could help the hospitality industry.
Thank you.
Thank you.
I have one question. The fee for the training that you developed, so the individual server pays that fee, or the restaurant can buy it for their staff?
The restaurant's buying it for the staff. Ideally, the way it's supposed to work is that the restaurant would buy an individual training per employee and then give them their key code to take the training. But what we've seen because of cost is even sometimes they'll buy the training and show it to like a group instead of individually because of the cost.
Interesting. Thank you.
Thank you.
Questions?
Thank you. No, I don't have a question, but I just love the idea of the traffic light kind of approach. It's very interesting. Thank you for sharing that.
Sure.
My question actually on that traffic light approach is, since that article came out, have other restaurants adopted it?
I don't know the answer to that. I haven't done any more diving into it or contacted the restaurant to see how it was working. But I would say due to the disruption that the industry has seen, I'm not sure that we've seen it take hold the way it should. But now that we're having this conversation, maybe we can start to research that a little bit more and find out for you. We could certainly contact California and find out how it's gone.
Interesting. Thank you.
Thank you very much. Our next presenter is Seher Kawaja. She is the Senior Attorney, Economic Empowerment, Legal Momentum. Did I pronounce your name correctly?
You did an excellent job. Good morning. My name is Seher Khawaja, and I am a senior attorney at Legal Momentum, the Women's Legal Defense and Education Fund. For over 5 decades, Legal Momentum has been at the forefront of using the law to advance gender equality for women and girls, and we're honored to be here today. I want to start by thanking Commissioner Reardon, Commissioner Imperial, and the Governor's Office for holding this hearing and inviting us to be part of this important discussion. Through our work, we regularly see employers falling short in addressing sexual and other forms of harassment. And one essential way to advance transparency and accountability is to ensure that employers have a legitimate written policy that is enforced. By requiring written policies, New York is leading the way, and the state has created a valuable model policy for us to build upon and strengthen. Today, I want to briefly cover 5 areas where we can work towards strengthening the state's efforts to meaningfully address workplace harassment, including collecting data and information to assess progress, prioritizing the needs of our most vulnerable workers, fostering an approach that addresses the spectrum of sexual harassment, eliminating procedures known to disempower victims, and addressing inequity more broadly. The first gap we are facing is a lack of information. New York's legislation thoughtfully included a periodic review to maintain progress, and we are especially heartened that the Department of Labor and the Division of Human Rights in the Governor's Office has engaged in this broad consultative process so that we can keep moving forward. Yet we still lack critical information to adequately assess our progress. We currently know very little about employer compliance rates and impact on workers, including the extent to which workers are aware of internal policies, feel comfortable using them, and whether these policies have facilitated reporting of sexual harassment. Worker voices and experiences must drive this process. Although reporting or auditing measures might require changes to the underlying legislation, the state should also consider any monitoring or reporting that could be carried out and consider conducting surveys, which could be done through the state's new sexual harassment hotline with a few simple questions for workers. Employers should also be encouraged to carry out internal audits and to track data on harassment complaints. This approach would help us better understand how these policies are functioning and better prepare for the next review. A second gap we need to address is to center the needs of workers who are especially vulnerable to workplace harassment, including women of color, immigrant women, and women in lower wage industries, including domestic workers, farm workers, and hospitality workers. All too often, these women face unique and heightened vulnerabilities, yet they do not see their experiences reflected in guidance and policies. For example, we know that cleaners in office buildings, hotel workers, and farm workers are often at heightened risk of sexual harassment and assault because they typically work in isolated areas. While in the restaurant industry, the reality of working for tips can lead to higher rates of sexual harassment. As the DOL and the division move to update this model policy, it's essential that we identify some of the most vulnerable sectors, engage in consultations with workers in these sectors, and use this feedback to shape the guidance. The DOL should also consider opportunities to issue industry-specific guidance, as we've heard from some of our colleagues. The policy should reflect a diverse set of workplaces and worker experiences, including those of women of color, LGBTQ+ workers, workers with disabilities, and immigrant workers. With respect to immigrant workers, the policy must be language accessible and account for the heightened risks faced by immigrant workers who typically fear reporting based on the risk or threat of retaliation based on immigration status. And the policy should account for these risks and can address them in examples throughout the policy, including the retaliation section. And I feel like this is an area where New York has enacted expanded protections, and this would be a great place to mention those as well. Our third recommendation is for the policy to go a step further in guiding employers to address sexual harassment earlier. Laudably, the model policy acknowledges that harassment need not be severe or pervasive to be unlawful. However, we know that sexual harassment continues to thrive in workplaces where less severe forms of conduct are tolerated, harassers are emboldened, and misconduct escalates. We therefore suggest the updated policy go further. Specifically, the policy should explain that employers should make clear that there is a range of prohibited conduct and corresponding range of proportionate corrective actions that can be taken, depending on the nature and severity of the conduct. Employers should be advised to intervene early to prevent misconduct from escalating. And employers should be directed to ensure that all staff responsible for administering the policy are trained on the policy and the legal requirements. Time and time again, we have found that leadership and HR personnel are ill-equipped to handle sexual harassment complaints in a competent and sensitive manner, and they get the law wrong. This often leads to either victims being disempowered and not heard, or it results in unnecessary litigation of claims that could have easily been internally resolved. As a fourth recommendation, it's critical that the model policy avoid practices that disempower complainants. For so many of our clients, the process of challenging sexual harassment is traumatic and disempowering, and most question whether or not it was worth it when everything is said and done. Going forward, we must do our best to shift this dynamic. For example, the current model policy notes that investigations are confidential to the extent possible. However, this type of confidentiality, this vague confidentiality, has long been used by employers as a shield. After a complainant has gone through the traumatic process of filing a complaint, employers often provide minimal information, telling them only that a complaint was founded or unfounded and denying them additional information based on confidentiality grounds. This approach leaves complainants in an impossible situation, unable to even plan for their own safety and well-being at work. The policy should make clear that complainants should be entitled to receive basic information pertaining to their complaint, including the determination made, the basis for the determination, and actions taken, if any. Lastly, we commend New York State for amending its law to address harassment based on all protected characteristics, as we know well that harassment, like other forms of discrimination, often occurs based on intersecting forms of identity. As the policy is updated, it should reflect this broader prohibition. Moreover, to eliminate workplace harassment, we need to address underlying workplace culture, as we have found that sexual harassment thrives in workplace cultures that are hierarchical, less diverse, and less inclusive. Therefore, the policy should encourage employers to consider deeper structural changes to advance civility, inclusivity, and equality. These underlying drivers of inequity have to be tackled before we can make meaningful progress. I want to again thank the Department of Labor, the Division of Human Rights, and the Governor's Office for this opportunity to share our thoughts and for your leadership on this issue. And we hope you will continue to rely on us as a resource going forward. Thank you.
Thank you very much. Very comprehensive. Any thoughts?
I'm just interested in hearing if you have any suggestions for the deeper structural changes that you might require employers to do to address the culture, workplace culture.
In terms of the deeper structural changes, I think those can be incorporated at so many different levels. I think they happen in the hiring process. I think they happen in terms of kind of the factors that are looked at in bringing on staff, and I think we very rarely look at, do our employees and do our leaders value diversity? Do they value equity more broadly? Do they value, creating an environment that is not conducive to discrimination? And I think so hiring is one area, leadership is another area. We oftentimes look at workers' performance when we advance, but when we bring in leaders, so oftentimes we're not looking at, do they value diversity and inclusion? How do they treat every member of the workforce? Because that really does matter. It's great that you have all of these qualifications, but do you treat your workforce with respect? And I think oftentimes we hear behind the scenes that people in positions of power oftentimes lack that broader respect.
Great, thank you.
No, thank you.
Thank you very much. Next, we will hear from Tori Newman, the Legislative Director of SEIU 1199.
Good morning, Commissioner Reardon, Commissioner Imperial, and Council Fine, and good morning to everyone else in the room. Thank you for the opportunity to speak here today on behalf of over 300,000 New York members of 1199 SEIU. We appreciate the Department of Labor's steadfast attention to the implementation of the New York sexual harassment policy in different industries and inviting us here to speak today to the effects of the policy on workers in the healthcare, specifically home care industry. Home care is a very unique job. Unlike other industries, a home care worker's work environment is the home of the client. This can be an apartment or a house. Cases can run from 4 to 24 hours, and consumers can live alone or with family. A major part of the job for home care workers is adjusting to new environments with every case. As a home care worker, physical care is an important part of many clients' care plans. This includes grooming, cleaning and bathing, and changing of diapers. Many home care workers will tell you this aspect of the job helps build a trusting relationship with the client, as many of them rely on this daily care because they're unable to perform it themselves. But this intimate care can also sometimes expose workers to sexualized acting out and other difficult behaviors, both intentional and as a result of a client's capacity because of dementia or other conditions. Home care workers can also be the target of harassment by family members or friends who are present in the home. Recently, an 1199 SEIU home care member filed a complaint to her agency because she was sexually harassed and accosted by the brother of her client. He rubbed up against her from behind twice, and when she asked him to stop, he told her he would, quote, kill her or beat her up. She continued to work with the family because she was afraid of retaliation from the brother or the remaining members of the family. Most home care workers are women, often immigrants, who are overworked and underpaid. They can come into the industry with a degree of vulnerability and feelings of powerlessness, which can lead to these occurrences going unreported and seldom addressed either in policy or practice. Home care workers facing sexual harassment from clients or other people in the home are in a vastly different situation than people who face harassment in an office setting, in a factory setting, or in other workplaces. Being in someone's home adds to the vulnerability a home care worker may feel in an instance of harassment, and without a clear plan from the agency, it will get overlooked. With the lack of formal reporting, it is hard to know the extent of the issue in the industry. But with more policy changes, we can make a difference in home care workers' abilities to come forward with harassment complaints without the fear of retaliation. The New York State policy should acknowledge that there are workers who work in a home setting and can be the target of harassment by non-employees, which would include their clients or consumers, family members, or friends of the client who are in the home. The law should require employers to respond and take action to protect employees when complaints are made, but also require employers to educate workers about reporting instances of sexual harassments that may occur in the home. Employers must communicate to home care workers that such behavior by clients and other people in the client's home are unacceptable. The law must encourage employers to create an environment where workers can feel secure coming forward to report such instances of harassment without the fear of retaliation by their clients or family.
Thank you.
Oh, thank you so much.
Thank you very much.
Thank you.
Next, we will hear from Gabriela Rendon, who is the staff attorney for Gender Equality Law Center.
Good morning, and thank you for this opportunity. My name is Gabriela Rendon. I am a staff attorney and community outreach coordinator at the Gender Equality Law Center. The Gender Equality Law Center is a legal advocacy center that advances laws and policies that promote gender justice and racial equity in schools and in the workplace. We have helped hundreds of New Yorkers access and secure justice in the face of discrimination through our free legal services. Enforcing sexual harassment and assault prevention is part of our work. For that reason, we are grateful for being invited today to provide our input to the current New York State Sexual Harassment Prevention Model Policy. First, on behalf of the Gender Equality Law Center, we want to recognize that New York State passed one of the most progressive sexual harassment prevention laws in 2018, when it mandated that virtually all private employers must provide sexual harassment prevention policies and training. For smaller employers with limited resources, the New York State model policy provides an opportunity for them to easily distribute the existing policy to their employees. We applaud that this policy was created by the state and that it is available on the state's website.
The major problem that we have identified is the lack of compliance with the law because many employers fail to distribute a policy or provide training. Almost all of the individuals that we have represented never receive from their employer a policy, a training, or information about their rights to be free from sexual harassment and retaliation in the workplace. As you can imagine, this presents various issues such as workers don't know what conduct constitutes unlawful sexual harassment, workers do not know where, to whom, and how to file a complaint, and they are unaware of forums available to enforce their rights outside the workplace, just to name a few. So there's a need for compliance and outreach. Our recommendation in this regard will be for the Department of Labor to establish a mechanism or a procedure to check if employers are conforming with the law and to establish penalties for failing to distribute sexual harassment prevention policies and training. Another idea is to provide information on a checklist format, for example, about what laws a New York State employer needs to comply with, what policies, trainings, and notices an employer needs to provide to its employees, and what are the consequences for not complying with them. The state of California recently made a change on its model policy. Their model policy now must include a link to their sexual harassment prevention online training courses. New York should also include in their model policy a link to the New York State sexual harassment prevention online training. Additionally, we suggest the inclusion of information about the new New York State workplace sexual harassment hotline. In a remote or virtual work setting, the lack of in-person witnesses and the ability to say or share things on a potentially unmonitored platform may embolden harassers to do things that they wouldn't do in person. For example, in some cases, we have seen workers that communicate through the application WhatsApp using their personal phones. And the chats or group chats that are created using this app are not monitored by their employers. The New York State model policy should include a section about remote or virtual platforms and explain that these platforms could be considered an extension of the workplace, and employers could be liable for the harassing conducts on these platforms. At one point, the current New York State model policy on page 4 discusses how harassment over social media is still harassment. So this could be a good place to expand and explain what is remote, virtual, and social media harassment and add a few examples. Now that more employees have a hybrid work mode or work remotely, it is important to make it clear that the New York State model policy applies to employees who work for a New York State employer, regardless of where the employees are domiciled. For example, an employee who works from their home in Connecticut for a New York State employer is sexually harassed by a coworker through a Zoom video call. The employee may incorrectly believe that because they live in Connecticut, they don't have the protections under the New York State law. We also suggest inclusion of information about the new federal law, Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, for workers to be aware that this law prohibits employers from enforcing pre-dispute arbitration agreements and class action waivers that concern sexual harassment and sexual assault claims. And finally, from our clients and through our trainings, we have learned that discrimination is still pervasive in New York State workplaces, and most low-wage workers don't know about their rights. Many workers don't know about other protected characteristics, such as immigration status or national origin, and that they can intersect. For instance, they incorrectly believe that if they file a complaint for sexual harassment, they will expose themselves to be deported. As a result, they remain silent and they endure the discrimination. For that reason, as a next step, we hope New York will create similar policies to cover other protected characteristics, such as race, national origin, immigration status, etc. Thank you very much.
Thank you. It was great. Thank you very much.
Thank you.
Next, we're going to hear from three presenters from the IATSE. Leah Oken is the business agent for the Theatrical Wardrobe Union, Local 764 IATSE. Elizabeth Pecos is IATSE Motion Picture and Television Department International Representative and the IATSE DEI Committee Co-Chair. And Eileen Mcdonald is a worker and member of IATSE Local 1 Stagehands and founder of Local 1's Sisters Committee.
Good morning. My name is Leah Oken, and I am the live performance business representative for the Theatrical Wardrobe Union, Local 764 of the International Alliance of Theatrical Stage Employees, IATSE. If you were at home during the pandemic and you watched reruns of The Office, that's the little bug you saw at the end. Local 764 represents wardrobe workers and costume shop employees who work on everything from ballet and opera, television shows, to the recent immersive Stranger Things event. On behalf of the workers we represent, I would like to thank you for this important training. Before the requirement that employers provide sexual harassment prevention training, most employers in our industry did not provide any instruction to their employees. In the past, the union would have needed to bargain over this with each individual employer. It is unlikely that they all would have agreed to provide it. The law has removed that burden while providing comprehensive standards that all training should meet, and we are very grateful. As you contemplate the future of this program, we would like to mention that individuals who work for multiple employers, which is very common in our industry, may be required to take this training over and over again, 4 or 5 times a year, maybe even twice in a week. And we would request that you consider allowing individuals who work for a multiple employer group, this would include things like different Broadway shows, because each of them is an individual employer, be allowed to take the training one time and present their certificate of completion to the other employers in the group. This would streamline the process for the employers, but still ensure that the workers receive meaningful training. And with that, I'd like to pass it to my esteemed colleague, Liz Pecos.
Good morning. My name is Liz Pecos. I'm an international representative in the Motion Picture and Television Department for the IATSE. I'm also the co-chair of our International Diversity, Equity, and Inclusion Committee. We are more than 150,000 workers and 360 unions in virtually all arts, media, and entertainment crafts of motion picture and television production, live theater, trade shows and exhibitions, television broadcasting, and concerts. Thank you for this opportunity to speak on behalf of entertainment workers. I'm a recent transplant to New York from New Mexico, and coming from a state that does not offer mandated harassment prevention training such as this, as many other states do not, I can tell you what a benefit it is to have a workforce that is trained in this manner. It is a crucial first step towards cultivating a safe workplace. In New Mexico and many other states without training, many workplaces are going unchecked for processes and implementation for harassment prevention, leaving employees ill-equipped to report any instances of harassment or discrimination. And although we've made strides as a society to shift the culture of harassment and bullying, we still combat these issues in our workplaces today, as we've heard reference to. Looking ahead at ways to enhance the training program, we are committed to seeing a safe and equitable workplace for people of color and LGBTQIA+ individuals, and believe the training could benefit from the addition of DEI elements such as anti-bullying and discrimination prevention woven into it. Thank you.
Good morning. Thank you for inviting us to speak today. My name is Eileen Mcdonald. I'm a proud member of Local 1 of the IATSE. I am a stagehand and I work on Broadway. Stagehands work backstage. We have the coolest jobs in the world. We do the lights, sets, props, and sound. We defy gravity, we razzle dazzle them, and we are in the room where it happens. We make the magic, but all of that aside, we are in a workplace. a workplace historically dominated by men that promotes a culture of drugs, sex, and rock and roll. Boundaries have never existed. I'm grateful for the New York State mandated sexual harassment training. In spite of the eye rolls and scoffs I hear around me, the message is clear. Don't be a jerk at work. I started my career in 1982, 40 years ago. There were virtually no women. The culture was to keep your head down and your mouth shut. There were no protections for anyone, and I put up with an awful lot because I love what I do. I've made every effort personally and professionally to improve the lives of our members. Local 1 has over 3,600 stagehands, and there are now just over 200 women in our ranks. 11 years ago, I founded the Local 1 Sisters Committee to bring the women of our union together to network, to support each other, and to step out of the shadows and become full participants of our community. Our international president has since mandated that other locals follow suit, and so far there are now 56 women's committees across the country and in Canada. We are starting to have a voice. Yesterday, September 14th, marked 1 year since Broadway reopened after the shutdown for 18 months due to the pandemic. I want to personally thank the Department of Labor for keeping so many of us afloat with unemployment assistance and the PUA assistance. The scary part of coming back to work after a year and a half is you simply cannot risk any job by speaking up. When you get labeled as a troublemaker, you do not get hired. This mandated training is the first step in changing the culture so that the fear of losing your job is lessened by shifting the burden to the employer to create a better and safer work environment and giving the employer the tools to make that happen. I'm grateful, I applaud you, and I thank you.
Thank you very much. Thank you. I have one question on the issue of the multi-employer. It's obviously something that has come up in various forms of work. You have multi-employer contracts, so they already come together, and you're saying that that might be an avenue to facilitate the training.
That's exactly right. Where there is already a multi-employer group for another purpose, and that's specifically where we see people having to take it multiple times within, like, let's say the same week. It's where people have multiple employers. Maybe they work for 2 different dance companies in a year. They may have to take it multiple times a year, but it's probably more stretched out. But if you are a dresser on one Broadway show, but then you do day work on another, you really could pretty easily stack up 4 or 5 employers that you work for within the same week. And so that's where we're seeing the really repeat. And they are a multi-employer.
Right.
That's a very
There are people who work for multiple employers over a year, but they're not connected.
Exactly.
And we wouldn't want to encourage that. But thank you very much.
Thank you very much.
Thank you.
Thank you.
So we are now going to move. Thanks again to all the presenters. We appreciate the insight and information, and we're now going to move to the public testimony portion of the hearing. I have a list of people who have signed up. So the first person on my list is Eileen Munoz from the National Domestic Workers Alliance.
Good morning. My name is Eileen Munoz. I'm the Enforcement Program Manager for the New York chapter of the National Domestic Workers Alliance and a former domestic workers. As a definition of domestic workers is a person who work in another person's home, such as nanny, house cleaners, or home aid for elderly or special needs children. New York was the first state in the U.S. to pass the Domestic Workers Bill of Rights in 2011, which include the first law to guarantee domestic workers legal protections against sexual harassment. However, it wasn't until last year that domestic workers were fully covered under the state and the New York City human rights law. While NDWA support the Department of Labor effort to provide a model sexual harassment prevention policy, the currently available templates do not make sense to the context of domestic work. For domestic worker, the human department supervisor, person in charge of payroll, is all in one person. And this creates fear for domestic workers to speak up. Employers or domestic workers still fail to see their home as a workplace. The moment a domestic worker sets foot into their home, the employer must behave in a way that respects the domestic worker as an employee. Employers in the privacy of home feel more free to act inappropriately. When I was working as a nanny, when the female employer was away, the male employer asked me to take a shower so he could see me. This kind of sexual advances and inappropriate touching is commonplace. Sexual harassment guidelines must be tailored to especially target domestic employers or domestic workers. To prevent sexual harassment for domestic workers, the New York State Department of Labor must invest in outreach to educate households that they are employers and must recognize their legal obligation. Prevention is not enough. Domestic workers also need access to social support and assistance in filing complaints with human rights agencies. The Department of Labor needs to provide resources and coordinations. Thank you.
Thank you very much. Next, we're going to hear from Vitra Shelley Halasi, also from the Domestic Workers Alliance.
Good morning. Thank you for having me here. My name is Vitra Halasi. I'm a domestic chef. I'm a domestic worker, chef, and a member of the National Domestic Workers Alliance. I'm here to share my experience in encountering sexual harassment in my former job. From 2017 to 2019, I worked as a nanny for a family who lived in Brooklyn, caring for their 9-month-old baby. The male employer, who is the father of the child I looked after, repeatedly made sexual explicit comments to me and made excuses to become physically close to me. Out of nowhere, he bragged about his sexual encounters with Black women and, in one case, a Black girlfriend or model he dated. Another time, he was playing basketball while I was watching his son and said he felt like he re-broke his rib. When I asked how he hurt himself the first time, he explained it was while having aggressive sex. Their bed broke and the person fell on him, breaking his rib. And do not mention this conversation to his wife. He would find ways to sit physically close to me. One day, I was on the computer shopping for kitchen houseware for the family's new home when the male employer came and sat extremely close to me, leaving no breathing room, making me feel uncomfortable. I slowly tried inching myself away. Before leaving, he patted my upper thigh. When I confided to a friend who referred me to the job about how I felt uncomfortable, she told the employers, who then immediately fired and accused me of lying. They then said lies about my work and threatened to take legal action against me. This was the same family who 2 weeks before had given me a glowing reference and sent it via email. The DOL needs to be aware of how sexual harassment happens to domestic workers behind closed doors and find a way to address it specifically. Thank you.
Thank you. Next, we're going to hear from Royce Bryant, also from the Domestic Workers Alliance.
Good day, everyone. My name is Royce Bryant. I'm a domestic worker. I'm a very proud nanny and a member of the National Domestic Workers Alliance. I am here to share my experience of an encounter of sexual harassment in the workplace. Employers must realize and be aware that domestic workers work in the employer's home. This is our workplace. Employers should always be dressed appropriately in their homes. For example, my previous boss would come out of the shower with his towel wrapped around his waist into my workspace. It made me very uncomfortable, and I was very concerned that if his towel should fall or come loose, it would be horrible. I would leave the area and would, I'm sorry, I would leave the area when he would do this. I even asked him very politely not to, but he continued to do so. Also, I worked for this employer for 5 years. Employees should feel safe and respected, just as we respect our employers. The DOL needs to be aware of how sexual harassment happens to domestic workers behind closed doors and find a way to address specifically. Thank you.
Thank you. Thank you.
Our next presenter is Sherry Goodstein from the Goodstein Law Firm.
Thank you very much. My name is Sherry Goodstein. I'm an attorney with the Goodstein Law Firm, and I'm here today testifying on behalf of NELA, the National Employment Lawyers Association. And I thank Commissioner Reardon and Commissioner Imperial and Counsel Fine for this opportunity. As you know, NELA are lawyers who represent employees and support employees' rights. And we are, first of all, very grateful for the protections that are afforded to employees by New York State and the recent legislation. What I'd like to do is take you through some specific clauses that we think could be strengthened in the model policy. First of all, we concur that the policy should cover other forms of harassment in addition to sexual harassment, should cover all the other protected classes. And I go back to opening remarks by Counsel Fine, in which you stated that it's unacceptable to go to work and be harassed, as it is, not just from sexual harassment, but from all forms of harassment, because at its essence, employees can't do their job if they're harassed or they are fearful from harassment. So it is imperative that the policy cover all forms of harassment to other protected classes. Number two, there is in the current policy, it says that the employer will conduct a prompt and thorough and fair investigation that ensures, quote, due process. And the problem with that affording of due process is, one, it's not legally necessary. There is no support in the statutory law or the case law that affords due process to the people who are accused of sexual harassment. And practically speaking, it becomes very difficult for the employer to carry that out. And it also impedes the ability to conduct a prompt investigation, to be able to conclude it, and to be able to give relief to the accused, to give closure. Once the investigation is concluded, remedial action is often taken. But when we open the door unnecessarily and not obligated the law to, quote, due process, it is creating a can of worms, which really creates untenable and unnecessary obligations for the employer to complete the very critical prompt and investigation of a good faith allegation of sexual harassment. Number three, there are numerous places in the policy that talk about reporting harassment. And I think it's important, and there is support for this, that should be replaced of reporting what the employee believes in good faith to be harassment. Because what if the employee complains about something that ultimately is not decided as a matter of law to be sexual harassment? They should be able to go forward and complain about what they believe in good faith is harassment. There's a clause in here about who this applies to. The policy applies to all employees, et cetera, contractors. It should also be added, government employees, employers of the legislature, and judges, which reflects recent changes to the law, which are very important to protect those groups.
We've talked a little bit about remote work, but there's a part of the policy that states that this policy must be provided to all employees and should be posted prominently in all work locations. Now that we have our virtual workplace, how do we do that? Where do we post it in cyberspace? I might suggest, if it's okay, I had one employer that when we logged in for the day, before we could reach our inbox, there was a certain policy, maybe it was about privacy or confidentiality, where we had to review it. We had to check that we reviewed it before we could get into our, our inbox and our work. And I found that to be effective as a possible solution because it is very difficult to figure out where to post these days. And then there's another clause in here that unlawful sexual harassment is not limited to the physical workplace itself. And it says that harassment can occur on away from the workplace premises, on personal devices or during non-work hours. And it should also be added or on Zoom or the equivalent to cover the way many of us are doing our work these days. There is another part, and this may have been addressed by others, but it defines who a non-employee is. A non-employee is someone who is or is employed by a contractor, et cetera. It covers gig workers, temporary workers, and it should be added here, as we've heard so eloquently from others today, domestic workers should be added to that definition. There's a section on retaliation, and we believe it would be important to add as an example of retaliation, given recent law, that retaliation includes but is not limited to making public personnel files, which came up in a very recent matter that we're all aware of. And those are most of our comments. We will be submitting written comments as well before the 20th. So thank you very much for the opportunity to present these views.
Thank you. That is the end of the list that I have, but I would like to open it up if there are other people in the room who would like to testify. We'd be happy to have you come forward at this time. So we're going to take a quick break and then we'll regroup. Thank you. So we're back. Welcome back. We are going to give you our closing remarks now, and we're going to leave we're going to stay here for 30 more minutes just in case somebody comes. We'll put a hold sign in front of the camera, but we want to be able to close at this point in case there is no further testimony coming up. So I will turn first to my colleague, Liz Fine.
Thank you, Commissioner. I took pages of notes. This was so valuable. I really appreciated hearing from our presenters, our public testimony, and it really underscores for me the value in this context and in every context from hearing from people who have the real world expertise, experience. That is really the best way for us to inform our policies at the state level. So I thank you so much for taking the time to come and testify and sharing your expertise and experiences with me and with us. It will definitely produce a better policy. And I want to thank the Commissioner again for holding these important hearings. The Governor, as one of her inaugural initiatives, reached out to every state agency and asked, please create opportunities for the public to participate in policy making. It is so important, and it does produce a better result for all New Yorkers. This is a great shining example, and I'm going to use this example over and over again to encourage similar kinds of efforts around the state. Thank you so much.
Thank you. Maria?
Sure. I'd like to thank each one of you for coming today. And I feel like I also learned so much and took so many notes as well. But more importantly, I feel like this is the reason why I feel so blessed to be the Commissioner of the State Division of Human Rights. I was moved by many of the things you said. I heard themes. Some themes that I heard was a need to look at the policy from an intersectional approach. And I know that that is so important because we all have many intersecting identities, especially those who are most vulnerable. So I just want to thank you. And I realize too that this is very much a human rights issue. If we just treat each other with basic human dignity, how far we could get in New York State. So thank you so much for making the time.
And for me, this has been really an amazing experience. When we first were tasked with dealing with this policy, it was something that I really embraced because it's something that I've experienced in my own life, in my former career, and I think it's deeply important. As Maria just said, we should all treat each other with a great deal of respect. The world would be such a better place. I want to thank each of you for your testimony. It was not only moving, but very clear and very helpful. And I've already had quick conversations with my staff about all the millions of things we now get to think about. And to Liz's point, the opportunity to create more engagement, more places where people can gather and have these conversations, you've really opened a door for us and really started us thinking in different ways. So I really thank all of you. And to the people who are watching online, thank you for joining us. Please be sure to submit testimony, online. I think it's through October 1st now, because we want to hear from you. We want to know what your experiences are, what your suggestions are. We can't change the law. That's up to the legislature, but we can certainly change the policy and the implementation. And we look forward to those recommendations and suggestions. This is an issue that touches everybody. It's not just a women's issue. It's not just a young woman's issue. It's everybody goes through this potentially. And so we all share a responsibility to help others in our situation, to be candid about how we think and feel about it. And I really thank you for your participation. We are going to put up the hold card for 30 minutes. If anyone does come in and want to testify, we'll be here to hear them. But again, thank you so much for taking the time to be here today. And I know that we'll be reaching back out to many of you for further conversations. Thank you. So we are back. Thank you for your patience. We have one more person who will testify, and she will be speaking Spanish, so we'll have an interpreter. Thank you so much.
Presente. Puedes comenzar.
Sí, no escucho mucho. No lo escuché, ¿me repite?
Puedes comenzar.
Sí, buenos días. Buenas tardes.
Good afternoon.
Mi nombre es Laura Cadena.
My name is Laura Cadena.
El motivo por el que ahora estoy ahí es porque
I'm here today.
yo soy víctima de acoso sexual en mi trabajo.
I'm a victim of sexual harassment at my place of employment.
A causa de esto, yo ahora estoy sin vivienda.
Because of this,
También
I am now without a home.
Tuve que ser medicada.
I had to
Fui
receive
al hospital, me
medication.
medicaron porque tuve ataques de ansiedad,
I went to the hospital. I was
pánico y
medicated
miedo.
because I had anxiety, panic, and fear.
Yo soy mamá soltera, tengo un niño de 16 años
I'm a single mom. I have a 16-year-old child.
y ahora me siento muy mal, muy triste porque me siento que no tengo apoyo de nadie.
And I am now very upset because I feel that I don't have support from anyone.
Y no tengo trabajo, también no tengo para comer, no tengo para darle a mi hijo de comer.
I have no job at this moment. I don't have enough to provide for food, and I can't provide food for my child as well.
Y también tengo mucho miedo de denunciar a esta persona porque no me gustaría que le pasara algo a mi hijo y me pasara algo a mí.
I'm also very afraid of reporting this person because I am in fear of something happening to myself or to my child.
Yo pedí ayuda a mi consulado mexicano porque yo soy mexicana.
I asked for help through the Mexican consulate because I am Mexican.
Y ellos me dieron asesoría
They gave me counsel
y me contactaron con ustedes,
and they put me in contact with you.
con la señorita Velázquez que ahora me está llamando. Me siento confortable, me siento bien porque estoy siendo escuchada
With Mrs.
y de
Velázquez.
alguna u otra manera sé que va a haber algo que me ayude.
Who is now calling me, and I feel somewhat comfortable. I feel somewhat relieved because I know that something good will come of this. I know there's going to be someone that will hear me, help me out.
Una pregunta yo quisiera hacerles,
I would like to ask
si
a
quisieran
question.
escuchar ¿cómo fue que se fue dando este tipo de abuso en el trabajo?
If you'd like to
Y
hear
cómo-
how this came about, this type of mistreatment at the job, at the workplace.
Eso fue algo muy duro para mí vivirlo.
It was something very difficult that I had to live through.
Me sentía muy hostigada, muy acosada.
I felt very harassed, very irritated.
Cuando él me despidió, yo sentí un alivio hacia mi persona porque ya no lo vería más.
When he fired me, I almost felt sort of a relief for myself because I knew that I wouldn't see him again.
Pero también la manera en que me perjudicó este despido fue que ahora no tengo dónde vivir, no tengo trabajo, tuve que ir al hospital porque me siento muy mal, me siento triste.
The way this harmed me in a way is,
Porque mi hijo va a la escuela al lado de donde yo trabajaba.
Laura, ¿me escuchas?
Sí.
Si quieres, hablen frases breves como estamos en vivo para que nos puedan escuchar, ¿ok? The way this harmed me in a way I could say is now that I don't have a place to live, I don't have a job, I also have nowhere to turn. And also before the situation with my son, before it would help me out, but sigue, Laura.
Y ahora pues estoy aquí y no sé qué va a pasar y están pasando los días y cada vez está peor la situación mía y de mi hijo.
And now I'm here and, I don't know what's going to happen with all of this, but every day the situation with my son and I worsens.
Estoy tomando el medicamento que me dieron los doctores y me provoca mucho somnolencia, mucho sueño.
I'm taking the medication that was prescribed by the doctors, but it does cause quite a bit of sleepiness.
Y tengo mucha angustia.
And I have a lot of anguish.
Eso es mi situación de ahora.
That is the situation that I'm going through now.
Y es difícil encontrar empleo. He estado estos días buscando empleo.
And it's difficult to find
Ahora en la
employment.
cocina,
I've been looking for employment these past few days.
porque ya no quiero ser cajera, ya no quiero que me vuelva a pasar lo mismo.
I don't want to work at the register anymore. I don't want to continue doing that. I don't want the same thing to happen to me again.
Muchas gracias.
Thank you very much. Gracias a usted.
So thank you for translating for us. And I want to thank her for telling us her story. Obviously, heart-wrenching. And I know that we'll reach out and see what other things we can do to help her. But these are the kinds of this is the impact of harassment on workers.
Su situación y obviamente lamentablemente ese es el precio que se paga cuando está envuelto uno en esas situaciones y vamos a ver qué más o qué otras cosas pueden hacer para ayudarle más.
Sí.
Excuse me 1 second. Okay. So at this point, we're going to hold for another 10 minutes to see if we have more testifiers to come forward. I think we're putting the camera on hold again. Thank you very much.